Am I audible? Right? Am I audible, guys? Nice. Okay. So, so, hi everyone. Now, what we'll do is we've discussed many things yesterday, right? Discussed about sources of law, right? So, are there any doubts regarding to the yesterday's topic, students? Are there any doubts? Okay. So we have discussed about sources of law, right? So yeah, can anyone tell what are the sources of law? What is mean by sources of law? What is mean by source of law? Can anyone? Can anyone? Can anyone tell me the sources of law? What is mean by the source of law? So, lawmakers, in order to frame law, in order to make law, there are three sources. They take law, they make law by taking three things as a main source. Okay, one thing is customs, the second thing is judicial president, and the third one is legislation. So in the last class, we have discussed about how can lawmakers make law by taking customs into consideration, and also we've discussed how is law made by taking judicial president into consideration. Yeah, so we'll just revise a bit, okay, a bit deeper. What we discussed yesterday. One is one is custom. The second one is judicial president. So what is mean by custom? Customs are nothing but it is previously observed continuously from a long period without any interruptions. We don't know from when it started, but it started in our country. Okay, from long ago. From long ago, right? So now, so we also discussed about the we also discussed about the classifications of customs, right? What are the classifications of customs? Point number one, customs are classified into three types. One is general customs, the second one is local customs, and the third one is conventional customs. First one, what is mean by general custom? Customs, which are prevail, which are prevail throughout the country, which all the states in our country follow. Those types of customs are called as general customs. Then what about local customs? Local customs are not, the law which is not prevail throughout the whole country, but it is a law which is prevail only to a particular state, only to a particular state. Am I right or not? Am I right or not, students? The third type of customs are called as conventional customs. Conventional customs. What is meant by conventional customs? Conventional customs are nothing but these are the customs. When two or more persons, what they do is they enter into an agreement. When two or more persons, when they enter into an agreement related to trade. So those types of customs, which are related to trade and business and profession, these types of customs are called as conventional customs. Did you get my point? So now we also discussed in the last session that the customs, what are the major tests, major tests of customs, right? Of customs. See, as I already said you yesterday, that customs, if at all you want to frame law from customs, customs have to be classified into four categories. One, it has to be in practice from long ago, from the period immemorial, that is, it has to be from antiquity. The third point is it has to be reasonable and it has to be rational also. The fourth one, if at all, it is being practiced in the society since a long period, but still, if it is immoral, lawmakers doesn't take that into consideration. It has to be moral in nature. It has to be moral in nature. Did you get my point, students? Any doubts, my dear students? Okay, so customs are of three types, and customs and are also, judicial juries and courts have laid some tests to be recognized as a source of law. So, while taking into consideration all the customs will be taken into consideration. No, four conditions have to be satisfied. What are those? One is it have to be reasonable. Only the things which are reasonable only it can be taken as a source of law, but not all the things which are illogical and which are not practical. Those customs have not to be taken into consideration. The second one is reasonable. Customs have to be reasonable only when it is taken, only when it is reasonable, we can take that into consideration. And the third one is antiquity. Antiquity means it has to be from immemorial. We cannot analyze from when it started, but it started. It's being practiced in the society now also from 10 or 15 years or some blah 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 blah, but it is in practice, right? Then last one is morality. The major source, the major thing to be taken into consideration is when the customs are moral. When customs are moral only, even if it is in practice since long, but still lawmakers doesn't take that into consideration. Lawmaker takes into consideration when when it is in moral nature. When it is in moral nature. Did you get my point? So these are the things which we discussed yesterday. So okay, any doubts in the yesterday's session about customs? I think that there are no doubts about yesterday's session. Okay, see Chetan, good explanation. Sir, I am white. Vaitu, hi Vaitu, how are you? So, Rob, I'm a big fan of. Thank you, Rob. What is your full name? Rob? Chetan. Good, sir. So, Chetan, did you get this point? Did you understand this? Vaitu? Good afternoon, sir. Haven't, haven't. Good afternoon, sir. Hi, good afternoon. Good afternoon. How are you doing, sir? Rob? I'm doing good, Rob. So, okay, so you guys have understood, I guess. So we'll go to the next topic. The things which we discussed yesterday. So let's rush into the yesterday's topic, which we've discussed. We'll revise it, and we completed customs, right? Now the second topic. Okay, Chetan. Yeah, Chetan. Okay, bye. Okay, now the second topic is, judicial president. Judicial president is something which we discussed yesterday also, right? Judicial president also will be taken into consideration while what? While, while making it a source, while preparing a law, while making it a law, lawmakers also take what as a source? Judicial president. Judicial president means the previously decided judgments. The previously decided judgments of superior courts are called as judicial presidents, and these judicial decisions can be classified of two parts. One is what? One is ratio decidendi, and another one is obiter dicta. We were discussed about ratio decidendi. Can anyone tell me about ratio decidendi, obiter dicta? Anyone? 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 So, anyone? Okay. Now, Okay. Now, yeah, ratio density is nothing but when a decision is taken in what, where in the court, that judgment, when the judgment which is taken in the court, when that judgment and that solution is binding in the future cases also as well, then that situation, that judicial decisions are called as ratio decidendi. Then what about obiter dicta? Obiter dicta is nothing but if at all, when a judgment is passed in a court, if at all you want to follow, you can follow. If at all you don't want to follow, there's no need to get worried. You cannot follow. So those types of decisions are called as obiter dicta. These are the things which we discussed yesterday. To revise, point number one, there are three types of sources. One is the customs. The second one is judicial wisdom. The third one is legislation. First, customs, I mean, not all the things which are practiced in the past can be taken into consideration. Only those things which are moral, which are reasonable, which are not, which are in practice from long ago, and from a period which is immemorial. If those four conditions satisfy, then what happens? It can be treated as a source of law. Not all the customs should be taken as consideration, but only things which are coming from a past. Okay, the second one is judicial wisdom. Judicial wisdom decisions also will be taken into consideration. These judicial decisions are of two types. One is ratio decidendi, then another one is obiter dicta. Ratio decidendi means what, my dear students? Ratio decidendi means whenever a decision is taken, whenever a judgment is taken in the court, that decision, that judgment shall be binding upon all the lower courts. Then that type of decision, judicial decision is called as ratio decidendi. When it is not to be followed, when it is not binding, then it can be treated as a obiter dicta. Yes. Now let's come to today's section. Today's session, it is talking about legislation, the third major source of law. The third major source of law is legislation. This legislation is derived from a Latin word legis and latum. Legis means law, latum means to make. So to conclude, the entire meaning of legislation means to make law, to make law. So how can we make law? How can we make law? Okay, how can we make law? The highest power to make law is given to Parliament, my dear friends. Is given to Parliament. Okay, is given to Parliament. Okay, see the primary legislation. This legislation is of two types: primary legislation and subordinate legislation. Primary legislation is enacted in Parliament. In case of central acts. In case of central acts, these power to make a law is given to Parliament. But what about the state law, sir? Sir, can we make law for only respective state also as well? Yes, it can be made, but for making laws in states, is it required for us to go to Parliament as well? As we've discussed right now, Parliament, central acts are prepared in Parliament or made in Parliament. Then what about state acts? State acts are also made in Parliament, but state legislature. Did you get my point? So where a power to make a law is given, it is given to Parliament. But what about the state laws? What about the state laws? State laws, to make a power here, to make a law regarding to the state, the power is given to state legislature. Did you get my point? So how can this law be made? How can this law be made is the question right now, which is faced by us. Am I right or not? So I'll just give you a detailed explanation. Okay. So okay. Let's 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 look at this. Okay, so okay, so when a concerned ministry, when a concerned ministry, see, we've discussed about Companies Act 2013, right? Companies Act 2013. So, if at all, if at people of 2013, how did they prepare law in those days? Or if at all you want to, if our government want to, or if our parliament. Okay, I'll just give you. I mean, you can get into a better understanding if you listen this. Okay, we'll have. You see, the thing which I am explaining now is about legislation itself. Okay, see, uh, point number one is legislation. Legislation means to make law. Okay, to make law. The highest power to make law is given to whom? It is given to Parliament. It is given to Parliament. So, if at all, if it is a central act, okay, so Parliament deals or makes or prepares a law. If at all, it is a state law. If at all people want to apply law to their state only, then we can make law to the respective state at what? At state legislature. Okay, at state legislature. If you listen to this point right now, which I am explaining, you'll get a better understanding, I guess. Please listen to this topic. Okay. So now, Tarun, hi sir, good afternoon. Hi Tarun, hi. So now we'll understand. See, if at all, people of 2013, we know that in our syllabus there is a topic called as Companies Act 2013. Yes. Okay. We have a topic called Companies Act 2013, and we also have a topic called as an act called as LLP Act 2008. Right. So we also have different acts, different acts like Factories Act, EPF and MP Act, and also ES Act and blah 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 blah. Right. So how I mean, what do you think? Do you think that these laws are made by customs, or do you think that these laws are made by judicial president? No, my dear students. These laws, okay, these Factories Act, it maybe Gratuity Act, or it may be any act. Okay, every central act and every state act shall be made by their respective things. Okay, point number one. If it is a central act, it shall be prepared. It shall be made by Parliament. And if it is a state act, it shall be made by state legislature. How can you say? How can you tell it? I mean, how can you say that Parliament, law is made in Parliament? Now, I'll tell you the whole procedure of the legislation or how the law is made. Okay, so if at all I want to make some act, okay, if at all I want to make some act, so what happens is people, the ministry, what they do is they prepares a bill. Okay, they prepare a bill and they pass it to Parliament. Then they pass it to Parliament. Parliament, there are two houses, right? One is Lok Sabha and another one is Rajya Sabha. What are the houses? Lok Sabha and another one is Rajya Sabha. Am I right or not? Guys, you there? So what are the two houses of Parliament? One is Lok Sabha and another one is Rajya Sabha. Once once this bill is passed in the Parliament, what happens is the bill shall be taken to a normal public. Okay, to public for their reviews. Sir, is this act, the bill which we are going to present, is it necessary or not? Will it be useful or not? Can we take that into consideration or not? So what they do is, as our India is a democratic country, right? Our India is a democratic country. It is a people's state. It is a people's state. Okay, people's country. Our country is a people country. So what happened? I mean, for the people, by the people, it's very important. So people's review is very important before making law. If at all you do not take the do not take the review of people, then what is the use? What is the use? Then it shall not be treated as socialistic or democratic or blah 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 country. It would be like like North Korea or any other countries. Our country is not like that. It is people's state. It is people government, right? So then that is the reason it goes to people. Okay, this bill and the review shall be made by people. If it is okay, then people give okay. Yes, it is okay. It is beneficial for us review. And if it is not okay, then just give the bad review. Okay. By after taking this review, and they'll also go to the experts also. Bill shall be passed to experts also. Experts, they'll also give their review. They will also provide their review. And after the experts providing their review and people providing their review, what happens is it shall again be taken to parliament. It shall again be placed in the parliament. Then the people of Rajya Sabha and people of Lok Sabha, what they do is they start voting. They start voting. They start what, my dear students? They start voting. Okay, once the voting happens, majority in the support to that bill. If majority supports to the bill which is passed, then it shall be taken to president, and president also what he does, and if it is satisfied with the bill, then president makes it as an act. President makes it as an act. Did you get my point? Did you get my point? Sadam, hi sir, hi. How are you? Okay, did you get this point? So, can you give me the procedure of this? Yes, I can give you a procedure of this. Point number one, bill shall be placed in Lok Sabha and Rajya Sabha. After that, it shall be taken to people. After that, it shall be taken to experts. And after the review, which is taken by both the people, it shall be placed to Lok Sabha and Rajya Sabha. And it shall be said that, sir, people, many of the people have accepted, and many of experts also have given their review, so that this is right now placed in the parliament. They say like that, and then they also take it to the parliament. And once Lok Sabha and Rajya Sabha also are okay with it, and they vote majority, by taking into consideration the majority, if majority is accepted with the bill, then it shall be taken to president. And if president also is okay with it, then it shall be made as act. It shall be treated as an act. Did you get my intention? Did you get my point, my dear students? It shall be made as an act. That is the reason. This is the process which happens to prepare an act, to make an act. Whatever the act you see, that act shall be made in this manner only. In this manner only. Did you get my point? You get my point? Okay, nice. Thank you, sir. Okay, now my question now is, see, if at all president doesn't like what decision taken by the Lok Sabha and Rajya Sabha, or he is not okay with the bill which is passed or placed to him, then can he reject? Can the president reject the bill? Can president reject the bill? Yes, of course, my dear students. President can reject the bill, and that power is called as veto power. That power is called as veto power. But this, when it is rejected, president has to give them proper reasons. You placed a bill, right? So that bill, I am okay with that bill. There is no problem in it. But you have to make small changes. So what happens is, president, what he does is he gives suggestion. He gives suggestions. He gives suggestions to change the little where it is needed. So if he says or if he gives his review, and after that also if the entire process is continued and it happens again, if this happens again and comes to him once again, now, now the second time, will he have the power to reject the bill? No, he is bound to accept it. He is bound to give his assent. He is not in a position to reject once again. If he rejects this once again, they will give him left and right. Seriously. Because this is not a small process, my dear students. This is a big and hectic process and it is very time taking. And this entire process, it happened in this much long time period, and you are telling only just a small word, rejected. How can you say that? How can you say that? They'll get, they'll get very angry, not even angry. President also has no power to do like that. President also has no power to tell them that no, this is rejected in the second time also. He does not even have power to reject second time. He also, he has power first time also. But first time also what he have to do is he has to just give reasons. While rejecting, he has to give reasons. That's it. Don't reject without giving reasons. Don't reject without giving reasons. That is what law says. Did you get my point? So, are there any doubts about it? So, let's read all these topics which we have discussed now. Okay. So, see, let's go to this. To article number 111, article number 111. Assent to the bills. Assent to bills. When a bill has been passed by Lok Sabha and Raj Sabha, that bill is presented to the president. The president shall declare that either assent or withhold the assent. As we discussed now, right? The president, what he can do, he has the power to withhold and also to accept. If at all he do not accept, if at all he rejects, he has to give proper reasons. He has to give proper reasons. He has to give reasons to withhold. Okay, what is the reason for him to withhold that? Next point. The president may return the bill if it is not a money bill to the houses with a message to reconsider the bill. I said no. I told you just now that president, if at all he want to reject it, he has to give what? He has to give one thing, that is reconsider. He has to give them one suggestion, that to reconsider. Guys, please reconsider. These are the mistakes which were made by you. Please reconsider. So he has to give suggestions where to reconsider, where not to take it out. Okay, did you get my point? So the next point, if the bill has been passed by the House with or without the amendment to the president, then the president is bound to give assent to the bill, but shall not. Now at the second time we discussed right now, right? The second time after president rejected this, and the entire process happens second time also, then on second time president can reject it. President cannot reject it. President is bound to say yes. President is bound to say yes. See, if a bill is passed again, if a bill is passed again by the House with or without the amendment to the president, the president is bound to the bill, but shall not. He shall not have power to reject once, twice, thrice, and many times. He has only power to reject only once. Okay, get my point. Next we'll go to the next point. After assent, Ministry of Law and Justice publishes the act in an official gazette. And see, after president says yes, this act shall be presented to official gazette, and in official gazette what they do is they officially declare that this act is an act and it shall be applicable to the whole country. It shall be applicable to the whole country. So see, after Assent, the Minister of Law and Justice publishes the act in Gazette of the India Extraordinary. Ministry of Law and Justice shall forward the copies to state government for publication in their official gazette. To all the state government, it shall pass to all the state governments. To what? For what? For what? For what? For publication. For publication in official gazette. So, are there any doubts? Are there any doubts? So, I think you guys have understood everything. Everything. So, just have a small reading about this topic. Okay, just have a small reading about assent to bills and also note this point. Note these points as well. I mean, this is pretty. Uh, you can understand LS. This is LS means Lok Sabha, RS means Rajya Sabha. Please, know, please understand my writing. Okay. So I think you've gone through this and you've noted these points. So now what we'll do is, if- yeah, now we've discussed that you know, the entire how the law is made in parliament. The same way, instead of parliament here, if at all, if at all it is a state act, if at all it is a state act, instead of parliament, it is state legislature. Instead of parliament, it is state legislature, and instead of president, it is governor who gives his assent to the bill to make it a, make it a law. Okay. So any doubts? Pakka? Damn sure. Now, now, till now we discussed about a bill, right? Till now we discussed about bill, and this bill passing in the parliament and assented by the president, and after the president assent, it shall be made as a law, right? You got my point. Okay, it is pretty easy. Okay, now before before this bill is present into the parliament, it has to become a bill, right? It has to become a bill. So now we are going to discuss how the bill is made, how the bill is made and prepared, and we discuss now it is how this bill is presented in the parliament. Now, how the bill is made, how the bill is made, that is what we are going to understand now. Okay, so now let's go. I'll just give you small understanding. Okay, so concerned ministry, what they do is, okay, what they do is they give before becoming bill. I said, okay, this now which we are going to discuss now is thing before becoming a bill. What is the procedure for becoming a bill? See, after becoming a bill, we placed it we presented it in a parliament, and we also took it to the public, right? Then now what we are discussing is this bill before becoming a bill, what is the procedure to become a bill? What is the procedure to become a bill? That is what we are going to understand right now. Now, let's go. So before becoming a bill, what is the procedure for making a bill? For making a bill, first, if the concerned ministry goes to the Ministry of Law and Justice, and not a Ministry of Law and Justice, a department of what? Ministry of Law and Justice. One of the Department of Law and Justice. What is the department? Is Legal Affairs, Department of Legal Affairs. So concerned ministry, what it does, it prepares what it wants to prepares and presents to Department of Legal Affairs of Ministry of Law and Justice. Then after this department reads everything, and if it is satisfied with the things which the concerned ministry have presented them, what they do is they make as a drafted bill. They make as a drafted bill. Once all the things which they have prepared, which the concerned ministry have prepared and presented to legislative department, the Department of Legal Affairs, what do the Department of Legal Affairs do is they make a drafted bill. Once the drafted bill is made, concerned ministry, what they do is they present it to public domain. And ask the public to give the feedback about the drafted bill within 30 days. They ask them to provide the feedback within 30 days. And after receiving the feedback from the public domain, what this concerned ministry do is they also go to the Ministry of Law and Justice. Sir, what are you talking? Huh? This is the Ministry of Law and Justice. This is also the Ministry of Law and Justice. Why they are sending 2 times? Guys, here the Ministry of Law and Justice, not the Ministry of Law and Justice, but to the Department of Ministry of Law and Justice. What department? Department of Legal Affairs. They send it to the Department of Legal Affairs. But here, in order to receive advice, they send it to Ministry of Law and Justice. Once the advice is received from the Ministry of Law and Justice, what they do is they send this for they send it for approval to whom? To cabinet. To cabinet for changes. For are there any? For approval. Okay, for approval, sir. We need. Are there any necessary? Is there any necessary to for us to change or not? So this cabinet, did you ever listen about cabinet ministers and blah blah blah? So this concerned ministry, what they do is they send to the cabinet so that they may get approval. And when this cabinet approves this drafted bill, this drafted bill becomes a bill. And once the bill is being made, then what happens? Then the procedure, what I said, the entire procedure, what I said, will come into existence. So this entire procedure to make a law, this entire procedure is needed, my dear friends. This entire procedure have to be made. See, here did you get my point? See, one is the concerned ministry. What they do is they go to the Ministry of Law and Justice for, in that also not the entire Ministry of Law and Justice, but for the Department of Legal Affairs. And what they do is they make a drafted bill. And once they make a drafted bill, what happens is they go to the public domain for feedback within a period of 30 days. And after 30 days, after receiving the feedback, they go to the Ministry of Law and Justice for what? For for advice. And after taking advice, they go to cabinet for the approval. And once the cabinet approves, it becomes bill. Once it becomes a bill, then it shall be taken to Parliament. Shall be taken to Parliament. Let's study the entire topic now. Okay, let's read it. Okay, let's read it. So point number one, what is the legislative process in India? What is the legislative process in India? The legislative process, the constitution is a primary source of India. Every law shall be in line with secularism, democratic values, socialism, and should also follow directive principles of state law. The law is preceded by the study on cost-benefit challenges, and also which is prepared by a ministry, consulting interest of all the stakeholders. I already told you, no? So here, see this concerned ministry, what they do? They present it to Law and Justice, the Ministry of Law and Justice for what? For after consulting the interest of all the affected states, after taking the effect of after taking consultation, who are the persons who are going to be affected, what is the thing which is going to be happen. So they take all these things into consideration. You get my point? Then what happens? Then what happens? The Ministry of Law and Justice, what they do is they make a drafted bill. After they prepare a drafted bill, this concerned ministry does is it gives to the public domain. It gives 30 days for them to give the review. And after taking the feedback from the public domain, what they do is their drafted bill shall be sent to Ministry of Law and Justice. Ministry of Law and Justice. And after that, what happens after here what happens after the advice which is given by Ministry of Law and Justice, they provide the entire drafted bill to the cabinet for what? For what? Approval. See? For what? Approval. So after for cabinet approval, suggestions after cabinet approval, suggestions of the cabinet are to be incorporated. The ministry makes statement of object and reason relating to the bill. The approved bill along with the statement of object and reason is then signed by the Ministry of Law. After this drafted bill, only when it is approved, it shall be treated as a bill. Only when it is approved, it shall be treated as a bill. And once the bill is approved, it shall be taken into consideration and presented into Lok Sabha and Rajya Sabha. And it shall be passed to Lok Sabha and Rajya Sabha. Did you get my point? So, are there any doubts? Are there any doubts, my dear students? Pakka? Damn sure? Are you okay with this? Okay. Now, what we'll do is I'll just give you this notes. Please note the entire points. Okay, note the entire points. And then what we'll do is we'll conclude the session. Okay, just go through with the topic. Just go through with the topic. Okay, and have a brief note about this. Let's go through and have a small notes on these things. So it is done. Okay. So I think you got all the points and you've understood the topic. So what we'll do is we'll conclude the session and we'll discuss the remaining topics in the next session. Okay. Take care. Bye bye. Have a nice day. All the best, guys. Bye bye. We'll meet in the next session. Bye bye.